it appears that the CII has done quite well. We also tried to advertise this webinar through all our different forums, and we expect this number of attendees to go up. I will like the participants to take full advantage of this knowledge session, and who are not able to attend, I will request people who have attended to please follow it, forward it to them, and if any questions are there, Mr. Pushkarna would be more than happy to answer. So with that, I welcome you all, and let us start this webinar. Thank you.
Thank you, sir, for such encouraging words. I am happy to share that today we have with us Sri Samanji Das, sir, Chief Commissioner of Customs, Delhi Zone. Sri Samanji Das is a post.
I think Shailendra is Chief sir is just not on the seat. I think just wait for 1 minute. He comes back then.
Okay, sir. Let's wait.
I think Samanji sir. Good afternoon, sir. Can you hear me?
Hello.
Yes, sir. Yes, sir. We can hear you.
I can hear you, but I cannot connect. I cannot connect the video. Just
connect it, sir. We can see you.
You can?
Yes, sir. We can see you. We can hear you, sir. We can start, sir. If you permit, sir.
I am happy to share that today we have with us Sri Samanji Das, Chief Commissioner of Customs, Delhi Zone. Sri Samanji Das is a postgraduate in economics and joined Indian Revenue Service in 1990. He has worked mostly in intelligence and investigation outfits like DRI, DGCI, and DGGI. At the time of implementation of GST, he was instrumental in setting up a National Anti-Profiteering Authority and had handled several anti-profiteering investigations. He was also the National Program Manager for the Indian Authorized Economic Operator Program. He was awarded the Presidential Award for Distinguished Record of Service in the year 2006 for his contribution in the field of customs, NDPS law, and enforcement. Sir, please enlighten us with a few words.
Okay. I'm glad to be a part of this webinar. I'm given to understand that this webinar is on anti-dumping duty.
Yes.
Before going into the details, I'd like to go to the economics and the law behind anti-dumping duty. To understand what anti-dumping duty is all about, one has to first understand what dumping is. And to understand what dumping is, one has to understand the various market situations. Typically, there are 5 sellers market situations: monopoly, where there is only one seller; duopoly, where there are 2 sellers; monopoly, one seller of one product; duopoly has 2 sellers of one product, an identical product; oligopoly is a market situation where there are few sellers of an identical product; monopolistic competition is a market situation where there are many sellers selling not identical products but very similar products which are perfect substitutes of one another. And the 5th market situation is perfect competition, where there are many sellers of identical products. Most widely prevalent market condition across economies is monopolistic competition, where there are many sellers selling similar products which are substitutes of one another. Now coming to dumping, in international trade parlance, a seller is said to be dumping when he enjoys monopoly in his own domestic market, but he prefers to sell his product in a foreign market at a much lower price. The primary reason behind dumping is overproduction or glut. There is excess unsold inventory with the seller, and that's why the seller chooses to dump his excess unsold inventory in a foreign market to avoid a price war in his domestic market. Typically, there are four types of dumping. The first one is sporadic, which is a relatively temporary phenomenon where the seller sells his unsold inventory or dumps it in a foreign market to overcome a situation of glut. Predatory dumping is a situation where the seller deliberately targets a foreign market to obtain a price advantage. This is the most injurious form of dumping. The third type of dumping is persistent dumping, where the foreign seller consistently markets his products at a lower price in a domestic market which has elastic demand. The fourth type of dumping is reverse dumping. In this kind of dumping, the foreign market has inelastic demand. So because of there is overproduction, oversupply, it forces the foreign seller to sell his goods in a domestic market at a lower price. So broadly, these are the four types of dumping that economies face. Now coming to the consequences of dumping, it causes injury to the domestic industry, which cannot compete with large-scale import of low-priced substitutes. The domestic seller gets marginalized and eventually is forced to leave the market. Coming to the remedy of dumping, there are broadly two categories. One is tariff measures and the other is non-tariff measure. Under the tariff measure comes anti-dumping duty, which is levied to provide temporary protection to the domestic industry against the low-priced goods dumped by the foreign seller. The non-tariff measure includes physical restrictions, quantitative restrictions, quota. These are non-tariff measures. The statutory framework for anti-dumping duty is derived from Section 9A of the Customs Tariff Act. When a product is exported to India by an exporting producer or country at a price lesser than its normal value, the central government by notification may impose anti-dumping duty, and the anti-dumping duty, mind you, it cannot exceed the margin of dumping. Margin of dumping is the differential between the normal value and the export price, the price at which the goods are exported to India. Normal value is the comparable price of like articles when sold for consumption in the exporting country. When there is a difference, when the export price is less than the normal price, the foreign supplier is said to be dumping in India. And in that case, the government can impose anti-dumping duty, which will not exceed the margin of dumping. Anti-dumping duty provides a level playing field, a kind of protection to the domestic industry against adverse impact of unfair trade practices like dumping, and it has its relevant framework under the WTO, the Customs Tariff Act, and the other relevant laws and international arrangements. The investigation of anti-dumping duty investigations are carried out by, earlier it used to be carried out by the DG anti-dumping. Now since May 2018, this is being done by the Director General of Trade Remedies. They not only do the anti-dumping investigations, they do the investigations for safeguard duty, for countervailing duty, and also they are also mandated to provide support to the Indian exporters who face such investigations in the foreign importing country. With this background, I leave the stage to the other participants. Thank you.
Thank you, sir, for such words. Now I would like to take this opportunity to introduce Sri Ajmer Singh Bisla, who is a senior advisor in direct taxation CII. Sri Bisla has more than 32 years practical experience and exposure to the tax administration in customs, central excise and service tax, covering manufacturing, services, import, exports, drawback and other export incentives and litigations. Presently, he is senior advisor to CII for indirect taxation and disseminates, collates and deliberates on the issues and suggestions of the industry on indirect taxes and GST for submitting recommendations to government for consideration. Also providing clarifications, advocacy, and had done hand-holding the industry during transition and implementation of GST. He is also qualified by NASIN and Apex Training Institute of CBIC for accredited trainer for GST and has organized more than 52 2 and 3 days GST training sessions. Also organizes interactive webinars and sessions to keep members informed of the updates on indirect taxes. Now I would invite Sri A.S. Bisla for sharing with us his views on today's topic.
Thank you, sir. Good afternoon to all. Our distinguished chief guest, Sri Samanjas Das, the Chief Commissioner of Customs, Delhi Zone. Sri Amish Kumar Gupta ji, Additional Director General, Taxpayer Services, Delhi. Sri Shailendra Kumar ji, Joint Director, DGTS, Delhi Zone. Sri Avinash Puskarna ji, former Commissioner of Customs, Central Excise and CGST. Other officers, as well as the distinguished industry participants. I would like to appreciate the constant efforts being made by DGTS CBIC to reach out to the stakeholders in dissemination of various measures taken by the government, giving clarifications and explaining the provisions of customs and GST law, schemes, and benefits available to the taxpayers. Requirements which are required to be complied, which may not be known in the intended perspective, or otherwise be interpreted in different manner. Interactive sessions with senior CBIC officials give an opportunity to the stakeholders to get deeper knowledge on the topics and understand the nuances of the provisions which help in good compliances and to avoid later litigations, tax demands, fines and penalties. CII, in association with CBIC, keep members updated, well informed about the changes made in the GST and customs law and procedures which enable members to do correct and timely compliance and avail admissible benefits, which are also save their lateral regrets for the mistakes. During the past couple of months, government, particularly CBIC, has focused on simplification of compliances and issued clarifications on many contentious issues as required by the taxpayer. Going forward, I give credit to the DGTS for selecting the unique topic on anti-dumping duty, which was otherwise untouched till now. Many importers face the imposition of anti-dumping duty. They may be unaware whether it is applicable when imported under FTAs from third country or through other suppliers. Hence, face the brunt at the last moment, which costs them heavily and business cost increased drastically. This lack of proper knowledge also gives rise in litigations, coupled with cost of time and money, which can otherwise be better used for their businesses. I would like to mention that the concept of ADD in the country was introduced first in 1992 after the 1990s tariff cuts. With declining protection where tariffs and quotas had dramatically increased use of anti-dumping by India. Over the years, India has become the world's leading user of anti-dumping measures. India has filed roughly 20% of all global anti-dumping cases, which is quite disproportionate to its share of global imports by 2%. It is seen that very few cases are dropped after investigations or recommendations. There can be various reasons for dumping, which our worthy Chief Commissioner has already explained. Anti-dumping has been quite effective at providing protection to Indian manufacturers in the categories in which it has applied. However, it is to be seen whether it is hampering the global competitiveness of Indian industry by providing the protection and to what extent it is adversely affecting the development experiences of the economies. So though ADD is imposed after proper investigation on material injury to the Indian manufacturer with the dumping of goods at lower prices than their cost, there has been a contrary opinion by both the parties to this investigation. We have also seen many complex issues coming from the Indian manufacturers and importers, like sunset review mechanism, retrospective imposition, expiry of effective notifications, but again imposed after the initial timeline is over, etc. So sometimes the description or classification of the goods is ambiguous or have a very thin line to give rise to controversies. It is also seen that for some product, 8-digit customs tariff is changed, but the ADD notification is amended within the time to cover the same. Enforcing officers also draw sometimes very narrow interpretation to cover even salts and esters of a pharmaceutical product under the ambit of the anti-dumping provision. All these variations give rise to unwarranted litigation, and we hope that presenting officials will cover all such aspects exhaustively. There is also a sister tariff measure, as the Chief Commissioner has also mentioned, that is in the shape of safeguard duty and countervailing duty. So hope that the concept of these duties and the difference between both shall also be covered today. So today our participants shall get the views of government's perspective, precautions to be taken by stakeholders before imports, concerns and expectations of authorities from the taxpayers in the present day ecosystem. Hope that participants shall be immensely benefited with the deliberation. Q&A and chat window shall be open where participants can ask questions. I would request that questions should be brief and clear so that these can be answered properly. Questions may be put in the window in one go and not in piecemeal. Also better if the questions are limited to today's topic only. I will not take much time, which otherwise should be taken by the expert officials for deeper deliberations on the concept, precautions to be taken by the importers, their liabilities of ADD provision. So with this, I stop here and thanks again to the DGTS and worthy Chief Commissioner for this opportunity to CII and the stakeholders for the much appreciated interaction. Thank you, sir.
Thank you, Sri Bisla, for your opinion, views, and sharing hands-on experience. Now for the presentation, I would like to introduce Sri Avinash Puskarna, an officer from the Indian Revenue Service, superannuated as Commissioner of Customs, CGST and Central Excise in the year 2020 after more than 34 years of service. He received the Presidential Award and Medal for Distinguished Record of Service in the department in the year 2019, as well as the World Customs Organization's Certificate of Merit in the year 2014. He is presently associated with a reputed tax and legal consultancy firm. Welcome, Sri Puskarna.
Hello, may I begin?
Yes, sir.
Okay. A very warm good afternoon to everybody present on the stage. And it's really my privilege and honor that I have been given this platform to share my views and also the experience which I've gained in the department for my association of almost more than 4 years. First of all, I thank you, our Chief Commissioner, Mr. Samanjay Das, for giving a background on the anti-dumping duty and fighting certain I had upon. I wanted to make it very simple, but I'm very thankful to you for your kind words and for the wisdom you have shared with us. I hope participants, apart from my presentation, will also be further encouraged, and also they will be getting more knowledge out of this thing. Now, I know that this program is primarily meant for the people from the trade. Of course, there are people from the customs formation and centralized formation also, no doubt. But these are the people basically who are from the trade who face difficulties, as Mr. Bisla has just now mentioned. That they wonder that there are so many duties, basic custom duties, and then the countervailing duties there, then special duties there. Then why all of a sudden this anti-dumping duty comes and safeguard duty comes? So when they come and all these things, they are totally troubled. So they all need to understand, and they have to be given this kind of background that why anti-dumping duty is important. What is the background? What is the reason why it is done? Before this thing, I would now just request the coordinators there that they can share my screen so that I can start the presentation, and then accordingly, because the time is not much, so I'll speak simultaneously when the screen is shared. Yeah, thank you so much. So basically, as our Chief Minister just mentioned, the anti-dumping duty in custom in India is basically meant for protecting the domestic industry for the injury which the goods manufactured in India suffer of similar or like nature. India, as you know, has got many industrial belts and produces many kinds of goods. They are kind of interdependent. Next. Yeah. As we all know that historically civilizations and countries have been trading in goods depending on the level of their manufacturing capacities. Now you see why it is there, because of geographical locations and the stage at which the stage of their economic development. We all know that various countries, either they are certain minerals, certain agricultural products, likewise. But as you all know that when industrialization took place in the European nations, totally changed altogether. It was such a famous country producing so many goods, almost was at the receiving end when we were in. First the Portuguese, then the Britishers, French, Dutch, and Danes. And what happened that India's nascent those industries which were really throbbing at one point of time, those were destroyed, and we at one point in time are only feeding the raw materials and minerals and even agriculture products for the production centers based in Europe. Like you remember cotton, raw cotton India was producing, and India was making very good cotton also here. But when the Britishers came, they had their industries, they wanted raw cotton from this side, and then they were manufacturing goods, and those goods were coming into India. That is in the past. That is what happened. So anyway, that is just an example. So what I'm trying to say is that because geographical location of the development has got capacities, the world as such cannot survive on its own. If we say that okay, India can, like even though now we are saying we are having Make in India campaign, no doubt, we may say that we can totally thrive on our products. Not possible. Even if you're having a good manufacturing capacity, you will be requiring some raw material, you will be requiring some semi-finished goods from outside. Similarly, we also send a lot of raw materials from India to other countries. So there is an interdependence of trade. So this has been going on historically in various countries, in various civilizations. As you all know, China had a long established Silk Route for its trade, and now they have tried to revive the Belt and Road Initiative. As you all know, China is a thriving economy which has really totally changed the rules of the game for the world trade altogether. And now it has 2013 onwards has started the China-Pakistan economic corridor for its energy needs, for its secure energy needs, having the China-Pakistan economic corridor on. So this is just a backdrop. Now coming to what kind of commodities the world trade involves. These can be agriculture commodities, which can be stated with raw materials, or even raw vegetables.
Avinash sir, your voice is breaking. Your voice is breaking. The connection is getting little, Is your connection fine, sir? Because your voice is breaking.
Achha. I think I don't have any problem with the connection. Are you able to hear me now?
I can hear you now.
Yes, sir.
Okay. Okay. Then I'll make it a little slow so that it doesn't resonate. Okay. Now, as you see, agricultural commodities, then when you have various countries have these manufacturing capacities, they can process those agricultural commodities and produce processed product. India also has come a long way from being primarily an agricultural commodity market. Now it has gotten even for a long time we have been processing and exporting the goods. Then we have crude oil. As you all know, India is a major importer of crude, and also we have got a lot of refineries. That when we import crude oil, we further refine that, and then we are able to export petroleum products. Panipat is a case in point, and there are many other companies operating under this. Then ores and granules. We import and we also export, whether they are iron ores, like you know in Goa. Recently, that Sasago company's name was there, who are dealing in this iron ore exports. Then we have semi-finished goods. Finished goods also, as you all know, electronics are being imported, machineries are being imported, and as regard the raw material we are importing, if we see our import basket, we are importing crude oil, we are importing coal, we are importing rough diamonds, and rough diamonds are brought into India, and India is a very big hub, like in Surat and Gujarat, where the diamonds are cut and polished, and ultimately those diamonds are exported. And in our export earning, diamonds also almost. Then pharmaceuticals, we are importing API, that is active and manufacturing medicines, and India is a very big exporter of generic medicines. Then there's rubber, plastic, electronics, and machine. I'm just trying to give you a backdrop that the world trade as such, no country can say that it is self-sufficient and it can survive on its own. There has to be interdependence. It is going on. Next slide, please. Yeah. No, what is important is that there has to be free flow of trade, no doubt. But any game, like our chief minister spoke a few moments back, that there has to be level playing field. So a game has to be played as per the rules. No one country can have a dominance over another country, because then there will be chaos, then there will be destruction of industries. So free flow of trade is there, but the game has to be played as per the rules. And that is why, from 1948 to 1994, we have trade and tariffs. But that agreement was primarily for trading in goods. When the goods were being imported into India or being exported from India, those GATT regulations. Then it continued, and ultimately we saw, and then you also saw that there was rise in China. China till 1990 was nowhere. In fact, India and China were almost at the same pedestal. But in China, industrialization started taking place, and they changed their game. They even gave their subsidies and I will not go into that thing. And China started changing the rules of the game. And there was cannot go by what is GATT. The things have to change, the things keep on evolving, the rules have to change. And if there are disputes, there have to be some dispute settlement mechanism. And that is why in 1995 saw the birth of World Trade Organization, which we know presently as WTO, which besides goods, just on this topic.
Sir, your voice is breaking.
Should I change the position then? I'll just change the position, maybe it will become better. Just 1 second. Is it okay now?
Yes.
Okay. Yeah, I've changed the position now. I think now maybe I'm better audible. Is it okay?
Right now it is okay, sir.
Yeah, okay, fine. So now what happened that in 1995 came WTO, and WTO, apart from trading in goods, also covered trade in services and intellectual property. And with the creation of WTO, we also had new procedure for the settlement dispute. Sorry, I got interrupted in between. I was touching on the topic of intellectual property. You must have, I think there are many people now who are from the present generation, but people of that generation would be knowing that how China systematically violated intellectual property rights. There was a huge piracy, and how duplicate goods were produced, and they were exported or even smuggled to other places, even destroying the industries. So things changed. That is why even intellectual property was also brought in the ambit of World Trade Organization. Coming to the next slide, please. Yeah. Now, many of you must have heard of this clause, Most Favored Nation Clause, that is MFN. You know, this is the founding principle of the WTO. Somehow, when we hear this phrase, Most Favored Nation, so we feel that okay, we can give a Most Favored Nation status to one particular country. No, that is not the case. In fact, when we say Most Favored Nation Clause, it implies that it is a requirement that countries providing a trade concession to one trading partner are supposed to extend the same treatment to others also. Because nowadays, it is not being bilateral trading only, there is multilateral trading under the WTO. But of course, there are certain exceptions. That is, you have certain trading blocks like the United States, Mexico, Canada, or the European Union. They are allowed to discriminate to some extent against the import from outside the bloc. And for trade preferences extended to developing countries also. There are certain developing countries, of course, because their level of development is lower. And if the world trading and world as such has to survive, it is very important that even the developing countries or even the countries who are lower than that, who are undeveloped, they also need to develop. And that is why World Bank keeps on giving assistance to them, because unless there is development all over, the trading will not be fair. And then trading in services to a limited basis also are granted some kind of exemption. Now coming to the next slide. Now with this background, next slide please. Raviji, next slide is not coming. Hello.
They're doing it. Just a minute, sir.
Okay. Just one moment. I think till the time they are not able to do, I have got my backup on my phone. Instead of wasting time, I'll start speaking if you don't mind.
Yeah, please continue. Please continue.
Yeah. So then, after talking about these things, that world trade has to be governed by rules of the game, and also there has to be non-discriminatory treatment to other countries, barring some exceptions. We come to 3 trade defense instruments provided by the WTO as protection in specific cases. Those are, number 1, anti-dumping duty, which is the present topic, today's topic. Then we have countervailing duty. And these two are permitted for the violation of the MFN clause. That is, most favored nation clause can also be violated by the countries in these 2 cases through anti-dumping duty and countervailing duty, and depending on the conditions which emerge when these duties have to be applied. And then there is another one called safeguards duty. This is the third one. This previous slide, I think. Yeah, here. The next one. Oh, I think by chance something hasn't clicked. Next. The next slide, please. Yeah. And the third one is safeguards duty. Here, the violation of the bound tariff principle. When I'm talking about this, I didn't mention this thing. The first 2 duties, these are permitted. The countries can violate the MFN clause, and by imposing these 2 duties, and they can also violate the binding tariff principle. What is the binding tariff principle means? Supposing somebody is importing from outside, then there has to be predictability that what is the tariff. It should not happen that all of a sudden some new duty is imposed. So that is a bound principle. But it may happen in case of anti-dumping duty, which was not there all in the tariff. But then these duties are imposed pursuant to some investigation based on the complaint, and then these duties emerge. So then in this case, India, any country can violate these principles of most favored nation clause and go for these duties. And same is the case with safeguard duty. It is also for the bound tariff principle. Mr. Saab had said that I should touch upon these 2 duties also. I'll do it little later after finishing the anti-dumping duty. I'll just touch upon these duties so that people can understand what is the difference between all the 3 duties. Next slide, please. Yeah. Now coming to the concept of dumping. Now when I see that what I am explaining and what Chief Minister Sir had explained already, he had explained with the vaster perspective and based on his knowledge of economics and his expertise. I am making it very simple. Dumping, when the exporter, here we are talking about the exporter, means the exporter from another country. Let us take, we are in India, there is an exporter from other country. When the exporter sells the goods in an importing country, that is India, at a price lower than the price at which the same or similar product is sold in its own domestic market, which is known as the normal value, then what is happening? We say that they are dumping the goods into India. And dumping is essentially price discrimination between national markets. This is, an unfair trade practice. See, an item which in your own country you are not selling at that price, that is not the normal price, and you are further going for the price cutting so that you can hit the other country and the product to the other country and causing injury to that. This is an unfair trade practice which can have a distortive effect on the international trade in the long run. Next slide, please. Yeah. And what is not dumping? I'm just telling, this is a little funny situation, but anyway, this is what I had seen even on the directed trade remedies frequently asked question site. So they said one should not assume that smuggling is also a kind of dumping, and smuggling in any case is not legitimate trade. So why I mentioned here is that when we are talking about dumping, we are talking about legitimate trade. We are not talking about smuggling. And sale of goods at low prices per se. But low prices means, okay, you can give some kind of discount. That is low price comparatively. But not such low price so as to target the industry and the product in another country and destroy the industry altogether. Then it may happen that there are certain goods which are not wanted or they are unsellable in the home market. Those goods are also exported to India. They may or may not be dumping here. Normally, if you say it is not dumping, but if India is producing similar goods and these goods which are being imported into India from another country, if they have the potential of causing injury, serious injury, like they can depress the prices or they can reduce the demand of the local product altogether, then of course such is dumping, and India as a country under the WTO as well as the GATT principles will be free to go for this anti-dumping duty. So now basically the fundamental notion of dumping is price discrimination. Whenever there is price discrimination of the export price of a product coming from another country into India vis-a-vis the price of the same commodity in India, then if there's discrimination to such an extent that Indian industry is going to be totally wiped out, or its profit margin is going to reduce, its prices are going to be depressed, then this amounts to dumping, which no nation would permit. And that is why under the World Trade Organization, which is now the umpire, you can say, and which is enforcing the rules of the game, under that you can go for raise a dispute. First of all, you can take these measures, and then these can be disputed, and then dispute can be settled later on at another different forum. Coming to the next slide. Now, anti-dumping agreement. Essential features. So what are the essential features of an anti-dumping agreement? These I'm talking about under GATT and under WTO. We have entered into agreements. Not only we, all the member nations have entered into these agreements. And as per these agreements, these are the essential features. Injurious dumping is considered as an unfair trade practice. Then it deals with the price behavior of exporters and not the exporting country as a whole. This is also a very important aspect. Sometimes we may think that anti-dumping duty, because the goods are coming from a particular country, that is why that country has to action has to be taken against that country. That is not the case, In anti-dumping, it can be one or two particular exporters who are creating this kind of problem, this situation. In such cases, later on, when the government, after investigation, that is, I'm talking about the Indian government, when government issues the notification, we also mention the name of the exporter as well as the country. But when it is happening in the country as a whole, when the goods from the country are causing injury to Indian goods, then the country is only targeted, and we need not mention the exporter's name. Then, most important thing is that injury to the domestic industry and causal link, that whether the injury which is being caused to the Indian industry is because of this anti-dumping, because of this dumping of the goods, that the goods which are being brought from outside, or there are other extraneous factors. This I'll come to later on. There can be other extraneous factors. For example, in India itself, there is some strike, there is some shortage already, for which foreign country or foreign exporter has no role to play at all. In such cases, you cannot say that I am going to impose anti-dumping duty. No, that will be unfair. Anti-dumping duty means you have to establish a causal link that domestic industry is being hit because of the price discrimination resorted to by exporters or maybe countries as such per se to cause that injury. Next slide. Yeah. Actually, I'm sorry because the time is short, so I'm just sticking to the point straight away. We can, so that we also have time for the question hour session also later on. And I hope I am clear because my slide is very simple and straightforward. Now, I'll again repeat here the purpose of that I spoke about the anti-dumping agreements. Now, the purpose of anti-dumping duty is to rectify the trade distortive effect of dumping and re-establish fair trade. That is what WTO wants, that the rules of the game have to be very fair. The game has to be fair. There has to be level playing field. There should not be any price discrimination. There should not be any intended injury. So anti-dumping measures are resorted so that this distortive effect of dumping is removed and we re-establish a fair trade. The use of anti-dumping measure as an instrument of fair trade is permitted by WTO, as I have mentioned. And let me clarify here that by adopting anti-dumping measures, India is not, we cannot say that India is a protectionist country. No, we are not going overboard to protect our industry. We are trying to protect our industry because of an intentional injury that is going to be caused to the industry because of the price discrimination resorted to by the exporters or maybe the countries per se. So what it does, the anti-dumping duty, when it is imposed, it provides relief to the domestic industry against the injury caused by dumping. I hope it is clear. Next slide, please. Yeah. Now, as sir had already mentioned, I am just touching on this thing. This is a legal framework for remedial action against the dumping. And how? First of all, specific action against dumping is taken in accordance with the Article 6 of GATT 1994 and Anti-Dumping Agreement, which I mentioned before. In the previous slides, I mentioned that we have entered into anti-dumping agreement like other member nations of WTO. We too have this agreement. And also we are following GATT 1994, General Agreement of Trade and Tariff 1994 principles, their Article 6. Under this, Directorate General of Anti-Dumping and Allied Duties, Department of Commerce, Ministry of Commerce and Industry is the designated authority responsible for conducting investigations and recommending duty level. And you know, basically a complaint because this is the Directorate General of Trade Remedies. They are providing the remedies. And here I will just try to distinguish. See, Indian Customs or Department of Revenue, Ministry of Finance, we levy basic custom duty. Basic custom duty is a kind of tariff barrier, no doubt, but that is permitted by the WTO, by the World Forum as such, that this much tariff you can put. And that is basically a kind of revenue raising measure. Because if India has to survive, and India has still not attained that developmental level, that is why the world, developed nations understand that we have got our revenue needs for the development of our country. That is why we can have custom revenue. So basic custom duty is there. And then there is CVD, that's the countervailing duty. Countervailing duty, I'll touch upon later on also, but I'm just sharing here. Countervailing duty, one duty is that which is equivalent to the central excise duty, as you all know, which is imposed on the goods if they have on the presumption that supposing they are manufactured in India. Then this kind of duty is levied on that. So that is basic custom duty and the countervailing duty or the CVD. So these duties in any case we impose, and that is basically for our revenue growth. But this anti-dumping duty is basically a remedial action, and that is the Department of Commerce is coming to picture here. So they, when the complaint is lodged to them, they only conduct an investigation. After their findings are made public, they forward their findings to the Department of Revenue. Then the Department of Revenue issues a notification under Section 9 of the Customs Tariff Act and Customs Tariff Identification, Assessment and Collection of Anti-Dumping Duties on dumped articles. These are the rules which are framed under this. Because see, how you can impose duty? Duty cannot be imposed by Ministry of Commerce because they are not the authority. You have to draw the powers through authority, through law. So legal authority is given to the Department of Revenue in that regard. Directorate of Trade Remedies is only conducting investigation. That is their authority. But our authority is to impose the duty under Section 9A of the Customs Tariff Act, read the rules on anti-dumping. Next slide, please. Yeah. Now we come to essential for initiating anti-dumping investigation. Now what happens? Supposing there are imports. Imports are going on, as you all know. I'm just giving you a background. Give me just 2 minutes. As you all know that till 1992, before India also had to go for liberalization and India also had to open its economy, we also had lot of non-tariff barriers in the form of licensing. I remember I worked during that period in the customs as an appraising officer in 1986 onwards till 1992. I remember we had such a big import policy with so many appendices where many goods were totally prohibited, certain were having some kind of licensing, but likewise they were different were there. But then those tariff barriers had to, non-tariff barriers had to be brought down because we wanted to open our economy to competition, because we had to take the World Bank loan, and that is what those are the conditionalities, that is the background which you all know. I'm not delving into that thing, but that is very important. That is watershed move, I would say, period. So in 1992, our import policy and export policy, they just shrunk from big volumes, and handbook they become small, because on very few items this non-tariff variant licensing came. Why I'm telling you what this thing is that with that, since we opened the economy, we reduced the non-tariff barriers, there was a surge in imports. Earlier, consumer goods were not allowed to be imported at all. And slowly, gradually, we had to bring down these non-tariff barriers. And apart from that, from 1994, you are not mistaken, we also brought down the tariff barriers. Our customs duties at one point in time used to be around 300% and 150% CBD and on whatnot. An item on an average used to have around 350% duty. That was the case in the pre-92, 92, 93, 94 period. But then gradually we had to bring down this tariff and non-tariff barriers and open the economy, because in 1995 with the World Trade Organization. So they changed the rules of the game. All the countries world over, they had to open the economies. But with the opening of the economies, with the surge in imports and the trade, these, I would say, concomitant factors also came into play. That they were dumping also, which was causing injury. So you cannot, nations have to balance both the things. You cannot totally allow your industry to be wiped out. Of course, it has happened in certain cases. I'm just giving you an example. Like in Delhi, I see, because I've been born and brought up in Delhi, I have seen that there was a time we had so many industries, but now you see all those in many industries have been, because of competition, I would say, they have been wiped out, and you have so many banquet halls standing over there. That is the reality we are facing. But also, consumer has become a king, because now consumer has a choice. There was a time a Bajaj Chetak scooter you had to have foreign exchange for booking. Now you are flooded with cars, you are flooded with mobiles, electronics, computers, whatnot, because we had to open the trade. But anyway, why I'm telling you this, that along with the opening of the free trade, there are abundant problems of dumping. So when this dumping is happening, the industry who is getting affected, they will come forward and they will lodge a complaint with the Director General of Trade Remedies. They will say there is a dumping and it is causing injury to its industry, and there is a causal link also between the dumping and the injury, that the dumped imports have caused the alleged injury. So these are the essentials on which the industry has to build its case and come before the Director General of Trade Remedies. No, coming to the next slide, please. Next slide. Yeah. Now I'm just going to elaborate upon that. How the Director General of Trade Remedies takes cognizance of such complaints. See, it is not that any stray industry in India, individual or single industry can just lodge a complaint. No, because World Trade Organization has laid down the rules, and that is what we are also following. It has fixed that the domestic producer who are expressly supporting the anti-dumping application must account for not less than 25% of total production of the like article by the domestic industry. Then only Director General of Trade Remedies is going to take cognizance of this complaint. And then the application is also deemed to be representative of the domestic industry if it is supported by those domestic producers whose collective output constitutes more than 50% of the total production of the like article produced by that portion of the domestic industry, expressing either support for or opposition, as the case may be. It may happen. Supposing even 25% have somehow garnered the support and they have come forward with a complaint. But then the DG, Director of Trade Remedies, has to see whether there is opposition to that complaint or people are supporting it. If it is more than 50%, then this Director will take cognizance of this complaint and then it will initiate investigation. Now coming to the next slide. Now we have mentioned in the past that what is anti-dumping? What is dumping? Dumping is that less than the normal price of the exporting country. That is the price at which the goods are exported into India. That is the price, that is the normal price, and then you have the export price. If there's difference between that, that is dumping. Now, what before that, so that is why it is very important to understand what is normal value in the country of export, which is exporting to India. Normal value is defined as the comparable price in the ordinary course of trade for the like product when destined for consumption in the exporting country, that is the home market. And when destined for, now this is the normal value when this trade within the country as such. Like in India also, when we charge duties, then we go for what is the value. For value, there is a definition given the earlier Central Excise Act, and in the Custom Act, what is value that is being defined. That there is a comparable price in the ordinary course of trade for the like product. And when destined, when we talk about the import price, destined for the same country in Indian imports, or when it is excise, we are talking about the domestic industry. Now, same is the case here. It is internationally accepted. So, in that country, what is the normal value? That is how it is defined. But then normal value, and why we have to take cognizance of this normal value? Because when the Director General of Trade Remedies is going to compute and going to formulate the anti-dumping duties, it has to take into consideration what is the normal value there. And when the normal value is not available, what can be done? And in what situation can be rejected? NV can be rejected when there is no sale of like product or when such sales do not permit a proper comparison. In such cases, NV can be export price to a third country or a constructed value, like we also do in our own India within the domestic tariff area. We go for it. If the value is not available, we go for comparison. We go for a constructed value, where you have the cost of production in the country of origin, the reasonable addition for administrative selling, administrative expenses, selling and general cost, and reasonable profits. Then you construct a cost. Then that cost is reckoned for the purpose of comparison. Yeah, next slide, please. Yeah. So the normal value is established only if the goods are sold in the exporting country market in the ordinary course of trade. And the sales are not regarded to be in the ordinary course of trade in the following situation. I'm further elaborating that. Where sales are made at prices below per unit fixed and variable cost plus administrative, selling and general cost. Or such sales are made within an extended period of time, normally 1 year, but not less than 6 months. You see, that is why even in customs and even in central excise GST law also, we go for the value we see almost the same point of time, maybe 30 days that you can, at the most you can take. Then only you can make a comparison. It is not that you will make a comparison of future 1 year or past 1 year. No, like that. It has to be almost the same time frame. Then only it will be a realistic comparison. And such sales are made in substantial quantities, like you can say weighted average of selling price below the weighted average cost. Supposing it may happen that even selling price is less than the cost price, how can you accept such value? You cannot accept. Or so even if there's 20% of sales by volume are below the cost price, then only that value cannot be reckoned for comparison, because that is going to cause distortion. So such sales are disregarded in the determination of normal value. Next slide, please. Yeah. Now, in order to have a fair, I'm just elaborating on that further. in order to have a fair comparison of NV and export price, several adjustments need to be made. Like it should be at the same level of trade. Now, what is that? Like in India also we do it at X factory level. And in respect of sales made at it nearly as possible at the same time. So X factory is the level when you compare the prices and then you arrive at what is the normal fair value of that thing. And then of course in that you can also give due account to these are the differences which are normally acceptable. Conditions in terms of sale, taxations, quantities, physical characteristics, levels of trade, and any other difference demonstrably affecting price comparison. Like what I mean to say, for general small trade discounts and all, these can be given. Like we also give in our customs and excise or even CGST. These are permitted. So this much leverage can be given. Then only we can have a fair comparison between the normal value and the export price. Coming to the next slide. Yeah. Now, here I am coming to the case of, say, let us say North Korea or even China. As I have mentioned, you even know, I have no this thing qualm in telling, and you also all know that China for a pretty long time has been giving subsidies to its products. That is why they were flooding of they could sell the product so cheap. So in case of non-market economies, here NV applies to economies where government has complete or substantially complete monopoly of its trade and where all domestic prices are fixed by the state. Now, sir had also spoken about these monopolies. So what will happen in such cases? When this is complete, you will not be having a fair idea of what is the normal value in such cases. So in this case, strict comparison with the home market may not be appropriate at all because monopolies are there. It is a state monopoly. How will you compare the price? You cannot take that into consideration to have a fair comparison. Or importing countries can exercise significant discretion in calculation of normal value. So therefore, in such cases, importing countries like I am talking about India vis-a-vis China or any other country, then we have been given this kind of leeway that we can have significant discretion in the calculation of normal value for comparison so that we can assess that what is that dumping, whether it is dumping or no dumping at all. Coming to the next slide. Yeah. So having said about all these things, now we come to, see, this is very significant. See, when we impose anti-dumping duty or the Director General of Trade Remedies, they recommend, then first what is important is that has to be ascertained is what is the dumping margin. Now here I'm just revising what I mentioned earlier. Now through illustration, I'm simply trying to inculcate so that you can understand that whether in this case dumping is there or not. Export price, we are talking about export price of the country which is exporting into India. Means the price at which it is exported to India. It is generally the CEIF value minus adjustments on account of ocean freight, insurance, commission, etc. to arrive at the value at X factory level, right? Then what is dumping margin? The margin of dumping is the difference between the normal value and the export price of goods under complaint. It is generally expressed as a percentage of export price. Now, here it is very simple illustration. Normal value has been ascertained as US dollars 110 per kg. Export price is US dollars 100 per kg. So straight away it is a clear-cut case of 10%, $10 per kg or 10% dumping. And dumping margin is 10% of export price. So dumping is basically a function of the two variables, namely that is the normal value and the export price that I have just explained. So that is how you arrive at the margin of dumping and what the percentage of dumping. So which must be compared at the same level of trade, that is at the X factory level. Next slide. Now coming to the significant part, that is establishing the causal link between dumping and injury to the domestic industry, which I touched upon in the beginning, in the previous slides. Anti-dumping duty shall be recommended only after establishing that dumping has led to injury and the causal link is established in terms of falling effect of dumped imports on domestic industry. Here I'm giving just two instances, and Sir Samanjas Das has already mentioned about these aspects. I'm not further elaborating because of shortage of time. So he has already given his words of wisdom and knowledge in the beginning. I'm just telling you about this volume effect and the price effect. What may happen, the domestic industry is going to build up a case and state that its causal link is how? First is volume effect. That the market share of the domestic industry vis-a-vis the dumped imports from the subject country. It may happen that when the goods are being imported into India, that is, I'm talking the dumped goods, you see the market share of the sale of dumped article is going very high. People are buying those. Domestic industry, the fellow is only rubbing his hand in dismay and wondering what is happening. So this is the volume effect. That they have taken away the volume altogether. How will you survive? There will be glut in the market for your own product. There will be stocks. Who are going to lift your stocks? Because people are buying only imported goods. That is one effect, volume effect. Second is price effect. If there has been a significant price undercutting by the dumped imports as compared to the price of a like product in India, or whether the effect of such import is to depress prices to such a significant degree or prevent price increase which otherwise would have occurred to a significant degree. That means here they are totally wiping your margin of profit altogether. The price is that. Supposing I am before this dumping takes place, let us say I have a product or the industry has a product which is doing good business. There's demand also. And yes, when there's demand, people also try to increase the profit, increase the margin. They may raise the prices. Normal. Apart from the raw material, they would like to have a better margin of profit. But here, when there's glut of foreign imports into India to such an extent that it's going to depress my own prices, how will the industry earn profit? How will it survive? So again, there is injury. So these are the factors in these are the causal link which the local industry has to project before the Director General of Trade Remedies, and once the Director General of Trade Remedies is satisfied, then it will go in investigation. They will investigate and then they will recommend whether anti-dumping duty is required or not. Next slide, please. Now here, in that I mentioned, now let us see how the Director General of Trade Remedies works. When a complaint comes to it, what does it do? First of all, it will see what is a non-injurious price. When we talk on non-injurious price means the price which has not suffered any kind of injury. That is our price. The price level charged by the Indian industry under normal circumstances during the period defined. This price enables reasonable recovery of cost of production and profits. And that is what is expected of any industry, any business. A business will run only when it is making profits. And then it can further, it may attain the economy of scale and all, but unless the business is having profit, it will not survive. Ultimately, it will become sick. So that is very important. The price level which is being charged in the industry, there should be enough to give it reasonable amount of profit and also recovery of cost. Besides the margin of dumping, the designated authority also calculates the injury margin for the domestic industry. The injury margin is the difference between the non-injurious price. See, that is why I'm defining it here. Because when DA, it conducts investigation, it has to see what is the injury margin. See, this is the non-injurious price to the domestic industry and the landed value of the dumped imports. Now, if industry is charging already say around 100 rupees, but that is the cost at which the goods are being sold and on which it is able to make enough recovery, profit as well as recoveries. But suddenly we see surge of imports and you find the same goods imported item available at 90 rupees. Now who will buy my product of 100 rupees? They will go for 90 rupees only. Naturally, it is going to cause injury. So this is what the Director General of Trade Remedies will see. Is there injury margin also? The landed value for this purpose is taken as the SSL value under the Customs Act and the applicable basic custom duties except for CVD, SAD and special duties. Now here I am talking about when the goods are being imported into India, export price no doubt, on that export which now become import price in India, on that basic custom duty is going to be charged. and of course other duties will be there. But the custom will see the applicable basic custom duty except for CVD, SAD and special duties, then what is the blended value for this purpose, for comparison. And once they compare and find that yes, it is going to cause injury, then it is going to go for anti-dumping recommendation. Next slide. Now what the DA does, DA means I'm talking about the designated authority in the Director General of Trade Remedies. It calls for the costing information of the domestic industry in the prescribed pro forma, and it says, okay, tell me, I'm just briefly telling you, I'm not reading the whole slide. It says, as per the accounting record maintained, as per generally accepted accounting standards, you give me all the data regarding the non-injurious price. Then when the DA will investigate and he'll estimate the non-injurious price, it will make an appropriate analysis of the relevant factors like usage of raw material, utilities, captive consumption, actual expenses including investment, capacity utilization, and the non-injurious price for domestic industry is determined considering the reasonable return on the capital employed, that is profits also. By taking into consideration the non-injurious price, that is the price of the goods in industry, that is in the domestic industry, is calculated first of all. Then we come to next slide. Now here the interested parties, very important here. I had previously told you that domestic industry 25% people are going to first of all make a representation, and then further they have to find support on another 50%, total 50%. Then only the complaint will be taken cognizance of. But it is not that straight away that designated authority in the Director General of Trade Remedies will impose this duty, recommend imposition of duty. No, it will weigh all the pros and cons. It will see the domestic industry, these are industry party. Then it will also take the opinion and the data from the exporter or the foreign producer of the like articles subjected to investigation. Importer of the same article illegally dumped into India, government of the exporting country and countries. Because see, nowadays we have to play the game, the rules which have been set by the World Trade Organization. It is a multilateral organization, I'm repeating again. So we cannot take any unilateral action. We have to have, as a democratic and represented body, I mean, this is what the mandate is. That is why we have to seek the opinion of all the stakeholders. So these are various stakeholders. Then trade or business association of the domestic producers, importers, user industry of the dumped product. It may happen that even our domestic trade bodies on certain occasion, they will say, okay, sir, the domestic industry, what we are getting the price, that is not good, and imported articles are better. They may say all these. So all these factors have to be taken into consideration. That what is providing fair competition and also sustenance. By taking into consideration to these things and by inviting the objections and opinion of all these stakeholders, the Director General is going to give his findings. Coming to the next slide. Yeah. Then the DA is going to decide that as per the WTO arrangement, national authorities can impose, because he is aware of this fact, that national authorities can impose duties up to the margin of dumping. As I had mentioned in the past, that supposing there is a 10% margin of dumping, so your anti-dumping duty cannot exceed that. It has to be up to that extent. That is the difference between the normal value and the export price. The Indian law also provides that anti-dumping duty recommended or levied shall not exceed the dumping margin. Once the opinion of all these stakeholders has been taken, calculations have been done, then the finding will be made public that whether in this case anti-dumping duty is required to be imposed or not imposed. And then those findings will be made public. They will also be recommended to the Ministry of Finance, Department of Revenue. Then there is a possibility that in certain cases, the total time taken for investigation may take long. But based on the preliminary finding, it appears that some serious injury is taking place. So therefore, this kind of redressal window is given to the Indian industry, that sometimes based on the preliminary findings of the DA, a provisional levy of anti-dumping duty is allowed. And there is a possibility that when the investigations are completed, if the same duty is confirmed, So whatever levy has taken place in the past will be confirmed. But if it is found that the provisional findings were there, but finally there is no case at all for levy of anti-dumping duty, then the anti-dumping duties levied will also be refunded. That is also there, of course, subject to the unjust enrichment clause and all. Those are there. But that also, because we have to be very transparent in that regard. We cannot operate unilaterally. So first is provisional finding, then there are final finding. So under the provisional finding, anti-dumping duty can be levied after 60 days from the date of initiation of proceedings. And the DOR, that is Department of Revenue, accordingly can issue a notification for such a levy. And generally it is levied in about 3 months. Whenever we in the Department of Revenue receive the findings, in a span of 3 months, the anti-dumping duty notification is issued. And the final notification is, supposing it happens that findings have been completed and a final notification is issued, it will remain in operation for at least 5 years, generally, unless there are certain factors brought to the notice of direction of trade remedies where it feels that no, okay, it is too long to continue the levy of that duty. Then, supposing the exporter of a foreign country or the country as such gives an undertaking, then these countries duties can be withdrawn also. But maximum period is 5 years. Coming to the next slide. Yeah. Now, here I'm just having said all about this thing. Of course, I know time is very short. That is why I'm keeping very to the point. I'm just giving you an example. In the year 2017, in the matter of aluminum foil, a notification was issued, anti-dumping notification. Here I am just reading because we have discussed about so many provisions. Section 9A is there, and then this whether it is injury, causal link, and all those things we have mentioned. So how an anti-dumping duty notification is framed, I'm just given an extract of that thing. So I'll just read very fast. Like Mr. Bisla had mentioned that about the tariff heading. So Department of Revenue takes care that the tariff heading is very precise, the description is very precise, so that it's not open to more than one interpretation. Anti-dumping duty, sir, if you see, they are quite comprehensive and minutely drafted, and all the details are captured there. So, and nowadays, for your information, I think there's an annexure under this Customs Tariff Act, where so many anti-dumping duties have been issued thus far. They have all been annexed together, and they are available at a glance, year-wise and content-wise, which is also can be sourced on the customs website cbic.gov.in, which can be seen. So I'm just reading very briefly and very fast so that I capture the essence how a duty notification under the Department of Revenue is issued after it received the recommendation for the Director General of Trade Remedies. It says the aluminum foil, which was a subject falling under Chapter 7606(7) of the First Schedule of the Custom Tariff Act, originating or exported from China PR. Now here it is country which is mentioned there, and imported to India. Now the designated authority in its final findings, now we are talking about the DGAR, then in its final findings, filed notification number so and so, which I told you, they have made public. DGADMIN, Director General of Anti-Dumping and Allied Duties, dated 10th March 2017, published in the Gazette so and so, has come to the conclusion that this is very important, that the subject goods have been exported to India from the subject country below the normal values. The domestic industry has suffered material injury on account of subject imports from subject country. The material injury has been caused by the dumped imports of subject goods from the subject country. So these three essential things have been mentioned in the notification which the Department of Revenue has issued. That is country, tariff, heading, items of description, everything is mentioned there. And the reason assigned are that they have been exported below the normal values, and the domestic industry has suffered material injury, and the material injury has been caused by the dumped import. That is, a causal link is there. It is not just out of blue something has been issued. Next part of the slide, please. So now it says, and it has recommended imposition of definitive anti-dumping duty on the imports of subject goods originating in or exported from the subject country and imported to India in order to remove injury to the domestic industry. See, all these things which I am mentioning, Department of Revenue so beautifully has captured in the notification itself. So there is no scope for any kind of misinterpretation or any kind of doubt or confusion. Everything is very clear here. So you have to read the within the line, between the lines of this notification, and you will get the essence of why this has been done. And therefore, in excess of power conferred by section number 1 and 5 of the section 9A. Section 9A is important section of the Custom Tariff Act, read with rules 18 and 20 of the Custom Tariff, identification, assessment, and collection of anti-dumping on dumped articles and determination of injury rules 1995. See, this is the background. Based on this, central government, that is the Department of Revenue, has issued this notification for levying the anti-dumping duty. So I'm not reading this thing now. I'll just come to the next slide. Next slide, please. Yeah. So what is mentioned there, I've just brought it in the form of a chart here. This is given the notification itself. I've just given one portion, just a detailed notification where the item description has been further amplified, And see, this is how the notification says that for anti-dumping duty on aluminum foil originating or exported from where? See, the various columns are there. Number 1. Number 2, subheading 7607, description of goods, aluminum foil. Country of origin is China PR, and country of export is also China PR. It may happen that sometimes country of origin and country of export may differ. And as you know, country of origin rule is very important. So that is both the columns have been mentioned here specifically, China, and country of export is China PR. And this is a producer, as I was mentioning earlier in my previous slide, that it's not only that country, it can be exporter also. Here the name of the exporter, producer and exporter has been given. And then the Director General of Trade Remedies, when in their recommendation, they have calculated that what is the margin of dumping. And that is why they have mentioned that clearly. It is not linked to anything else. Straightaway unit is per kg. So whatever may be your price, whatever you declare, what is basic custom duty, that is of no consequence now. They have seen that once the dumping is taking place, so this much duty has to be imposed in addition to the basic custom duty or special additional duty, contributing duty and all. So this is 1.43, currency also mentioned, US dollars. So 1.43 US dollars per kg anti-dumping duty is going to be levied on this particular product, that is aluminum foil, originating and from China and produced also there by these manufacturer and their exporter, because it was found that they are dumped items and because they were causing material injury, there was a complaint and there was a causal link which was established. So I hope I am very clear in that regard. Now I come to the next slide. Now I'm just giving you a few examples. I mean, because one may wonder that what are the items where these investigations are going on. See, as I told you, investigations also take time because it's a long-drawn procedure where complaint is lodged, support is first of all recognized. Then after that, we are inviting objections of stakeholders and all. After taking the opinion, then only a comprehensive notification after detailed calculations is arrived at. So the investigations are still going on. If you see the Director General of Trade Remedies website, you can see these are the currently few of the items. There are so many. I just taken just 9 of so that I can put them in one single chart. There are so many items, so many countries where the investigations are still going on because domestic industry has been telling that it is suffering material injury. So, for example, we have here, like in the past, I told you about the aluminum zinc foil. That is already a notification, but in this case, notification will be issued later on. But these are investigations going on. Anti-dumping investigation. Number 1, vacuum insulated flask or other vessels of stainless steel originating from China PR, digital offset printing plates, flexible flap stock polyol, chlorinated PVC, whether or not further worked and like that. Sorry, in the previous slide only. Penta-erythritol, isopropyl alcohol, halobutyl rubber, and all these. And then the countries you see majority in most of the cases is China, most of the cases. But you cannot say that the other countries are not resorting to this kind of practice, or certain exporters are not doing that. It can also happen in advanced developed countries also, like you have the example of Japan, Korea RP, Taiwan, Thailand, even Saudi Arabia, Malaysia, Norway also you see, Taiwan, all these countries are also involved here. So where investigations are going on. Now we can come to the next slide. So with all these things, I think it's going to be a heavy dose after lunch, but I think I have tried my level best that you don't doze off, and I'm trying to make my slide very precise and to the point, and also sticking to the time. It is 4:30 now, so I'm just giving a concluding remark now here, that one may wonder, when there's multiple duties imposed by customs, with basic duty, additional duty, that's the countervailing duty, special additional duty, why do we have this anti-dumping duty? Now it is basically, as I have mentioned throughout my slide, and as Sir Ardu had mentioned in the opening remark, it is a means to protect domestic industry from injuries caused by unfair trade practices. Although countries have opened up the economies for the free flow of trade, World Trade Organization recognizes that each country has a right to protect its domestic industry. Anti-dumping measures are not adopted as per the whims and fancy of the governments, but after careful consideration of the evidence adduced or rebutted by all the interested parties. Now, before I part, just small thing that I remember, one thing I've forgotten to mention, that is the difference between these three duties. That is anti-dumping, I already explained. Then I come to the countervailing duty. See, there are two kinds of countervailing duty. One kind of countervailing duties which we are imposing, which is known in our Indian in the country, is countervailing, that is CVD, which we call CVD, which is equivalent to the excise duty charged on the similar products manufactured in India. This is going on the assumption that when the goods are being imported from outside, they are not being subjected to the terminal excise duty. Like here also we do. In India, now the terminal excise duty is not there. I'm just giving you an example because now IGST has come. But earlier when the terminal excise duty was there, so when the goods are produced, after they leave, that is X factory, at that point in time, duty is levied. That is the terminal excise duty, which is refunded to the exporters, because when the goods are meant for export, after the exports are done, and one can claim the rebate or refund of terminal excise duty. So on the same assumption, we also assume that in the foreign countries also, to make their products competitive, they also don't apply this terminal excise duty. So since they are not being charged there, we are charging it here. That is a countervailing duty equivalent to central excise duty. That is number one type of. Secondly, there can be other kind of controlling duties where there are subsidies. Certain countries, like Europe for a pretty long time has been giving European countries have been giving this subsidies on their agricultural produce. Similarly, China has been subsidizing its exports. So in such cases also, the other countries in the world have been permitted by the World Trade Organization to adopt this countervailing measure. So that is anti-subsidy. So here in India also, that anti-subsidy notifications can be issued, but I am not going into that subject right now because the time is short. Then coming to the third type of duty, that is safeguard duty. Safeguard duty and anti-dumping duty, to a large extent, I would say, are the same. But there is very important difference here, that in case of safeguard, in case of that domestic industry has to adduce the evidence and say that in particular item it is getting hit by this thing, and that is why we are suffering, and that is why this anti-dumping measures have to be taken. But safeguard duty is imposed on all imports, irrespective of countries. Here we are country specific and export specific. That from a particular country like China, or from particular exporter of that particular country, goods are coming. There is price cutting is there, price distortion is there, and that is why we have to adopt this anti-dumping measures. But in case of safeguard duty, it is not country specific. If all of a sudden in India we find that there is surge in imports of a particular item, like example in this case, very live example is of solar panels. So when the solar panels were being imported into India, then the whole market was in a flux. They were hit. So domestic industry had to complain. It was not basically which country or that country, in general. So in those cases, also the same Director General of Trade Remedies can also go for imposition of safeguard duty, and that is also issued in the form of this kind of notification. And that duty also is also in addition to the basic custom duty and other duties like that. So that is the safeguard duty. But today the topic is not of safeguard duty, so I'm not further going to that thing because the time is short. So with this, I close my lecture, and I think I have broadly tried to and I've been able to impress upon everybody present who have joined this webinar to make them understand as to what is anti-dumping duty, what is the background, why they are imposed, what is the ultimately outcome, and what is the duration and all, and how they are different from the customs duty. So these are, unlike custom duties that are there to raise revenue, these are basically to protect the industries, but not protectionism. It is to protect. We are not being protectionist. We are being only protecting the genuine, legitimate industry against the legitimate import. Thank you so much.
Thank you, Sri Puskarna, for such an exhaustive and lucid presentation. And I am sure all of us have been benefited by it. Now I would invite participants for questions, if any. Please ensure that the questions should be relevant to our today's topic, and further the questions can be asked using the chat box.
There are some questions in the chat box. You can see and answer them.
No, I don't see. Let me see.
Click on the chat. It will show.
Yeah, I've clicked the chat. Let me see.
Can I take up the question from the chat box and then you can give?
Yeah, that will be better. I think that way we can save time. Yeah, please.
Thank you, sir. Thank you, sir. The first question is from Ram. Yes. He's talking about notification number 77 by 2021, Customs ADD dated 27th December 21,
Okay.
amended by notification number 15 by 22. Then he talks about the High Court order, Gujarat High Court order. The ADD on the subjected imported goods got reduced from 542 USD per metric ton to 297 USD per metric ton. The EDI ICAS was not allowing bill of entries provisional assessed to take amended tariff of ADD in the drop down menu. The amendment notification was not captured in respect of the same bill of entries filed before the date of amendment notification. The letter notification has the word amendment but not retrospectively. So in system, no final assessment could be done. Please suggest the solution.
Anyway, this is not in my purview, but I can only say that in this regard, to the Director General of Taxpayer Services, you can rake up the matter to the Director General of Systems, because basically when they
Yes, Mr. Bisla, these are some specific issues, and related to systems or related to the concerned assessment there. So, yeah, details can be forwarded to us, and we can ask the concerned formation to look into it.
I also think, sir, he should approach the concerned officer directly.
Yes, he should consult. In any case, if he has approached it, is not got a satisfactory resolution, he can give us the details. We can forward it and take it up matter with the concerned.
Yes, sir. Now, next question is from MC to everyone. Is not DGTR nodal for ADD?
Pardon?
DGTR nodal officer for ADD?
DGTR.
Yes, sir.
Ah.
Yeah.
Yeah. DGTR basically, as I just mentioned, it is whenever you have to lodge a complaint, the complaint has to be lodged with the DGT only, because they are the people who are going to remedy. They will first of all call for your objections, then they will see that there is sufficient support in the domestic industry, then they will have it investigated, they will seek opinion of various stakeholders, as I just mentioned. Then after that, detailed calculations and opinions only, they will recommend whether duty is to be imposed or not.
Sir, next also is from him. Also kindly mention some prominent dumping cases of India. You already mentioned and
I
covered.
already mentioned that.
Yes, sir. The next is from Santosh Gogave. If there is Indian subsidiary of exporting country, whether intercompany pricing is relevant?
Intercompany prices is relevant. I mean, he's talking about the exporting from outside.
Yes, sir. No, if he is importing from their own subsidiary, like that, sir.
No.
The Indian subsidiary of exporting country, whether intercompany pricing is relevant. So here the SVB may come into play.
Yes, they will come into play, because see, we have to basically see what is the normal price. As I've already mentioned, ordinary course of trade, what is normal price, what is time and place, all these factors are very relevant.
Yes, sir. And both these points are different, sir. SVB is something
and if at all there is
different, and ADD is something different. So ADD investigations has to be carried in a broader manner when in relation to some other importers as well.
Yeah. In any case, also in normal duty, also you see it the principle of arm's length, as you just mentioned with the special valuation branch. So the principle of arm's length has to be adopted. I mean, your relationship should not impinge on your pricing at all. If it does, then you are not dealing in normal trade. So, because
the next question is from NCG. Are Indian importers hand in glove with exporters? So we can't say, sir, whether some unscrupulous importers are whether a hand in glove with their exporters or not. So this is a subjective question. And no doubt ADD is imposed after thorough investigation. It is not like that. It is imposed just by per se.
And it's very transparent, as you have seen, I've just explained. It's a very transparent kind of mechanism.
Yes, sir.
It's not your whims and fancy that today will impose any kind of anti-dumping duty.
And it is available also, sir. If there is something.
And moreover, not only that, even if we impose, I think, as I've already mentioned, that since it is a multilateral trade nowadays operating under WTO, WTO is the umpire. So they can tomorrow people can take it and dispute there, and they'll be seeing that whether what we have done is correct or not.
Next is from Deepak Selvam. We are a buyer of Penta. Now ADD is imposed. When it will be applicable? But this is very typical question. We can't say when it will be applicable. It will be applicable as soon as the notification is issued.
Yeah.
But the policy matter of the government.
Yes.
Also, if the BOE bill of entry filed from the date of ADD, do we need to pay the ADD for all the purchased?
For all the purchased. See, basically, when the bill of entry, when the goods come, the duty will be applicable to all, and the date of your importation into India is that is the governing factor.
Sir, I think the question is incomplete. He may be saying that whether it may be applicable for earlier imports also. So personally, we do feel that it should not be
retrospective. I don't think it is only prospective.
Yes. For the goods which are covered in subject goods only, particular goods. If covered in the particular bill of entry, those definitely will be.
Yes.
And if there are some other goods also in that bill of entry, so those are, if not covered under ADD, those will not be covered under that.
Yeah, of course. Because the notification is specific about the particular description and tariff heading.
Sir, Mr. Jay is asking, we are a micro-scale manufacturer of industrial laser machines in New Delhi. We need some clarification regarding case number 7. I don't know date. They have mentioned the date, sir. 7th June 22 DGTR. The final finding notification.
Again, if some specific case is there, so they can.
That I think this is not the right forum to raise this question.
Yes, sir. It is a subjective matter and or for individual issues.
And for this, as you all know, since sir, you are from the CIA, you know that their local grievance cell and other forum are there where these issues can be taken up for escalation to the appropriate authorities.
Right, sir. We also don't take individual cases, sir.
Yeah.
if it is impacting general industry, then we can definitely represent. So now the Ritesh Kumar, my query is related to monopentapyrethrotol. Currently, major producer is Canoria, whose production capacity is 7,000 ton annually, whereas Indian demand is 3,000 ton annually. How come Canoria application is taken into the account? Again, sir, this is a
very subjective question.
We can't comment on this individual topic point, sir.
Because in this regard, I'm more about dietitian of trade remedies only will be able to answer that whether they they could garner the support of the other 50% or not.
Yes, sir. They take care on all such type of aspects, sir.
Yeah.
The time taken for DGS to finalize on ADD and issue notification by them, the Indian industry will suffer. Would you like to mention it?
Can't say.
Yeah.
It is the purview of DGTR. We cannot comment on that. If they have issues with that, they can approach the DGTR.
Then the next question comes: is there any notification? Can we add basic duty in ADD while filing the bill of entry to come to the landed value is more than the?
No. As I've already mentioned, it is very clear that ADD specifically as per unit in particular currency and the quantum is mentioned there. You cannot do that thing.
It is not possible to add ADD into basic duty, sir. All these separate.
Yeah. That is why they have been separately defined.
Separately defined, and we do have separate headings also.
Yeah.
Those also, everything is different. Sir, Yaswant, Mr. Jagdane, to everyone, is there any notification? Can we add basic duty? This we have already covered. Since my question has been missed, I am posting it again. Next comes, sir, from Della Cresta. Refer notification 16/2023, HS code 68069000 refers to gypsum tiles, where ADD is applicable, but would like to bring to your notice that this SS code also covers mineral fiber tiles and sheets. ADD investigative report also states that mineral fiber sheets are not liable to ADD, but still at the import clearance, the respective officers at FAG as well as the PAG demand for testing of the product to confirm if the same is gypsum or not. This is the time consuming, and for an AO customers, he has to forego DPD if samples have to be tested.
Now, in this regard, see, I have not seen this item, but if through naked eye, if we can distinguish that this product is that only, then I think the officers should not go for this kind of testing. But for that, I think the appropriate forum again would be the local commissioner and the chief commissioner level, that they can escalate the matter. That if they feel that they are getting unnecessarily harassed. And because see, customs people, the officer will also say they can always go to the higher authorities, because officers at lower junior level say that we have to protect our jobs. We don't know this is this or that. So if they can go to the next level at the deputy commissioner level and then explain the matter, and if it decide that it need not be tested, then they can just take it.
Sir, I would like to add here that this is a general type of questions. Many other importers also face, whether it is chemical or any other product. So we do have our distinguished chief commissioner today. So I would like to request him to, if he can give some, sir, his valuable views on this point, sir.
I missed the question.
The question is that he has imported some gypsum products which per se are not covered under ADD, but the notification covers gypsum boards under test ADD purview, sir. So the officer wants to send it for testing, and he is AO status holder. So he feels that he has to forego DPD, direct for delivery, for this testing, and the release is delayed.
I need to have the facts of the case, but since I am the convener of the National Assessment Center for this product, I have some idea. Gypsum boards or gypsum tiles, the issue here is whether they are just covered with paper or they are impregnated. Typically, impregnation of gypsum boards or gypsum tiles takes place by placing a resin impregnated paper on the tile or the board and then to treat it thermomechanically so that it gets impregnated. The board or the tile gets the strength. Some people take the plea that no, it's not impregnated, it's just the paper coating. That's why I think a decision has been taken at the national level that wherever there is such a dispute, many importers do agree with the view of the department and pay duty. But whenever the importers do not agree, samples are drawn and sent for test. On the basis of the test report, the provisional assessments are finalized.
Thank you, sir. We also do feel, sir, many times it is not possible for the officer to determine whether the product is same which the importer has declared. So to come at the correct classification of the product or the description of the samples are required for covering the risk factor. So that way, I think, sir, it is good for the department as well as the industry also. But my suggestion is that the officer should monitor such type of testing of samples or such type of delays very closely so that the genuine importers are not impacted with the delays.
And besides what I have already said, if the importer is a AEO status holder, they also get exemption from executing bank guarantees. If the importer is a AEO T1 status holder, he gets 25% discount. He has to execute 25% bank guarantee. If he's a T2 status holder, he has to execute. If he's a T1, he has to execute 50%. If he's a T2, he has to execute 25% bank guarantee. If he's a T3 status holder, he doesn't have to execute any bank guarantee. It's just a matter of the bond.
Thank you, sir. Sir, next question I take up. Dear sir, please advise, is from Mr. Manoj Kumar. If ADD wide notification number 25/21, ADD is coterminous with ADD wide notification 36/2017. Validity needs to consider from 2017 or 2021.
Very complex here because we don't have the notification before.
Yes,
One needs to take a look at the notifications.
Yeah.
Yes, sir. The question is also incomplete, sir. What he wants to ask on it. Next, again, question is coming for that demand of monopentaethylene. We have already replied that it is a subjective matter, so DGTR will look into it whether it is covered for their study or investigations or not. Next question coming from Puneet Panara. I recently showed DGTR website. There is so many ongoing investigations which is 10 years old. Is there any special reason for that respective case? If panel guide us about the process, it is really helpful to others as well. And what is this standard time?
Now, in this regard, I would say that since the Directorate of Trade Remedies is the body basically which is dealing with the complaint redressal and their investigation, I think they only should be approached. And already there is an online system also. They can ask them what is the position in this regard. Because when they are talking about the investigation, some complaint must have been lodged, opinions must have been taken. Now, what is the reason why the final investigation could not be completed? It will not be possible for us to say at this in this forum, on this platform. They need to take up the matter with the concerned authorities only.
Certainly, sir, because it is a matter of investigation.
Yeah.